right. Welcome to our webinar. This is 3 p.m. on Thursday, July 9th, and my name is Catherine Tran. I work with Ying in Community CPA. Very nice to meet you all. And so every day of the week we have webinars at 3 p.m. Today we have a special guest speaker who will be speaking on bankruptcy. During this time, it's very important to be educated and to know our options, right? So this is a very difficult time for many businesses. So we have invited our speaker. His name is Don Nguyen, and he is with Docuserv. He works with Community CPA to help us in our legal counsel. Welcome, Don.
Thank you. It's nice to have two Vietnamese without with the different last names. It's kind of rare, right? Because everybody, their cousin is named Nguyen. Anyway, so I work with Community CPA for the last 12 years or so. Prior to that, I was in California doing a lot of civil practice and some bankruptcy too. So today I'm just going to talk in very general terms about bankruptcy, what it's about, who qualifies for it, and what's the step we need to take. But more importantly, we need to inform people of basically whether or not it's the right option for you, and we'll get into that a little bit.
Perfect. All right, so I am going to start sharing our screen. And share. Yep. Can you see the screen, Don?
Yep.
Awesome. So as Don said, he has been in law for the past over 25 years and is licensed in Iowa and California. No responsibility disclaimer.
I wrote that, by the way.
Yes, thank you. And it's very important, right? Because even though this is valuable information, it is general and doesn't necessarily speak to your specific situation. So if you need legal counsel on for your business, for your individual circumstance, please consult a lawyer. And Don is happy to help you as well. So. Bankruptcy. So I know this can be a very scary type of thing. So could you first tell us, like, what is the definition and the purpose, and who can declare bankruptcy?
Bankruptcy is a procedure under the federal code. It's a federal law that allows people to basically wipe out their debts and start over again. It's a court procedure, so you make a petition to the court to say, this is what I have, and I'm asking the judge to discharge all my debts so I don't have to pay them back. So it's a lot of times it's the last resort for people who are too much in debt, and it's give them a chance to turn their financial situation around and start over again as far as money is concerned. There's the kind of stigma to bankruptcy before, but I don't think there is anymore. The economy is as such that it's starting to go down. When the economy was good, we don't see that many bankruptcy filings, but when it's starting to go bad, people losing money, houses, and things like that, they need that to protect themselves. So for what it's worth, our president filed for bankruptcy a few times, so I guess happened to all of us.
Yes. So any individuals and businesses can file?
Yeah, individual businesses, even government agency, municipalities, and even state can file for bankruptcy under bankruptcy law.
Thanks. And then, so when we're talking about it for individuals, then what types of options do they have? Are there different types of bankruptcy for it? And if you have a business, can you list it under your individual?
Yeah, 97% of the bankruptcy filing in this country are for individuals. The reason being, a lot of people don't have a business, but if they do, they can list that business under the bankruptcy. So the responsibility for the business and the individual are being discharged. Also, if you are a married person, both individual can file under one petition, and the business of either party or both parties can be listed under there. So it streamlined the process quite a bit for somebody to take care of everything in one shot. So yeah, your business is part of the bankruptcy. There's certain entity, like I say, like railroad, farming, and things like that. The bankruptcy process is different, so it had to be done in a different chapter. But for most people, and in businesses, there are two types that we're talking about. Chapter 7, which is a liquidation, basically. It's say, this is all I have, I'm going to quit, this is done. Okay, and the chapter 13, which is a reconciliation or basically you have to pay some of the creditors back for what the estate is worth. When you file for bankruptcy, it's create an estate, and within that estate, if the court determined that there's some of that estate that can be distributed to the creditors and maintain the business or the individual, then that should be allowed. But if the court determined that the Chapter 13 create less of an asset for everybody than a Chapter 7, in that case would be converted to Chapter 7. Most of the cases are Chapter 7, regardless of how it started. Eventually, most of them would start at Chapter 13 or 7 and then turn out to be 7 at the end. There are successful Chapter 13 cases in which the plan was developed for over a period of years or months or whatever the determination is, and then all the creditors pay part of what they owe.
Okay, so in terms of consequence, are there pros and cons of those two different chapters?
Yeah, because if you don't qualify for Chapter 7, because your income is a lot more than, is still a lot more than your debt, or your asset is still a lot more than your debt, then Chapter 13 will allow you to operate normally and just have a plan to pay back. Chapter 7 is a liquidation. That just means that everything is gone, I'm done. The term bankruptcy comes from when a shop, back in the old England day, when a shop is out of business and they can't do it anymore, they would break the bench in front of the shop. So there was the term, it come from broken bench. That's where the term bankruptcy come from. So back then it's only Chapter 7, but the law evolved into different chapter for different purposes because of the economy that we have today.
Awesome, thank you. And then, so those are the options for individuals. What about for business? What types are there for that one? And can a business stay open during the process? Like what happens if you have loans and other debts that you have to pay? I know a lot of people took out EIDL. What if you decide to file?
Yeah, for the bankruptcy for business, like I say, this other chapter depends on the characteristic of the business or the formation of the company. But most of the time it's found under Chapter 7 and Chapter 13 also. Chapter 7 will allow you to run the business until the trustee determined that the company is no longer there. Okay. Chapter 13, that's the benefit for the businesses. You can stay and operate as normal without paying your creditors or your providers or your suppliers. And if they agree to a plan to be paid back all or part of what they owe, then you can still operate the business as normal. So those Chapter 13 is a lot more complicated, more expensive. A company that's got a lot of net worth would consolidate and repay the debtor and things like that under Chapter 13. We see a lot of giant company that went Chapter 13, and then depends on the court, but it can be broken into little companies. It can have its assets sold off, but a bankruptcy under a big company can drag on for years, and eventually they either go out of business or they get or they survive the bankruptcy. A lot of companies do that, like Chrysler, for example. Back in the 80s, they filed for bankruptcy and then survived it. Even, I think, Detroit filed for bankruptcy and eventually survived it. But we're talking about small businesses and individual here. Fortunately, we have a good economy for the last 10 years or so. So the bankruptcy filing is really down, and that's a good sign for the economy. Unfortunately, this COVID-19, we believe in our community believe that the bankruptcy filing going to be going to go up, and we don't know how much is going to go up, but the number is going to go up. The problem is people, if they don't have money to pay for their mortgage or rent or things like that, they have help right now with the temporary laws that prevent them from being foreclosed and things like that. But soon as those are lifted, I think the bankruptcy filing is going to be a lot higher.
Right. Okay, so then what does happen if you took out loans? Are you able to include them in your bankruptcy claims?
You have to. If you have any loans, regardless of the characteristics and how much you still owe, if the loans are for an item with collateral, okay, it's not. Then you have to list that and you have to surrender the collateral. Say if you buy a car, okay, under the bankruptcy, as soon as you file, they can't go after you for the payment anymore, but they can go back and get the car. And they can't sue you for what you're short of the car. Any loans is the same. Okay, if it's a collateral, then you have to give it back, the collateral itself. If you buy a house, a building, and things like that. If it's an unsecured loan, then it can get discharged under bankruptcy. The EIDL loan is an unknown. We don't know at this point. I'm assuming it's going to be an secure loan. There's not, when you apply for it, you don't have to put up anything other than your words to get it. So I don't know, and nobody does 100%, but I'm sure that it'll be the same as any other loan that you get. The problem is if you borrow from the government, they can make changes like student loans or taxes and things like that cannot be discharged under bankruptcy. So if they make the EIDL loan the same way, then there may be a chance that you can't discharge it.
Okay, good to know. And then, so what are the effects of bankruptcy? Let's start by talking about the benefits first.
The benefits of the bankruptcy ultimately is to get your debt discharged, so you don't have to pay back anything that you owe. Also, the bankruptcy court will allow you to save your house. Okay, there's an exception for how much is still on your house, and you can keep your house. Your car, if you have a car, if it's under a certain value, you can keep it. regardless of how much money you still owe to the creditor. And the number one reason people file for bankruptcy is the automatic stay. An automatic stay say that when you file for bankruptcy, all creditors must stop collection. All foreclosure, anything that has to do with your debts, they cannot enforce. It's automatically stopped that very moment that you file, whether or not the creditors know it, okay? So if they don't know it, once they get the notice, they have to stop. And then while the bankruptcy is in place, you can live your life and don't have to worry about people coming to your door and knocking on it or stealing your, I mean, not stealing, but but take your car away while you're in the middle of the road, things like that. So it gives people a reprieve of all the collection and all the debtors going after them for the moment, okay? So that's the main benefit. But in the long run, it gives you a chance to rebuild. Okay, so that goes right into the negative consequences. Once you file bankruptcy, it's be on your record. It will affect your credit report. You
For how long?
To get a loan to do anything else, it's going to be there from 7 to 10 years. And even after that, it takes a little bit of time to rebuild it. People do it right away and to rebuild their credit, you know. As soon as they're done with the bankruptcy, they apply for those loans that you had to put a few $100s in the bank, secure a credit card, and then start building it from there. Have people co-sign for things, and eventually it will come back. People come back all the time. And that's the benefit. So you don't have to pay back whatever loan it is, whatever money you still owe, you know, utility bills that you hadn't pay. The only thing is you can't discharge taxes that are not personal income. It's like if you have payroll taxes, if you have other things like that. Or student loans, but there are exceptions to that now. And then and there's some exception to personal income taxes too.
Okay, excellent. And then so the main negative impact is the impact to your credit, correct?
Your credit score and your financial situation. I mean, this is a society that put a lot of emphasis on your financial situation and whether or not your history is good or not. If you're trying to get a mortgage after a bankruptcy, they wouldn't even talk to you. I mean, you know, you can't even get a loan for a car with a decent interest rate. They will loan it to you, but they want a pretty high interest rate. So your financial life going to be more expensive. But then since you didn't have to pay back all the loans and all the debts, it's a lot more manageable.
Right. Okay, thank you. And then, so now that we know about the basics, how do we determine if we should declare for bankruptcy?
The debtors are to a point where they cannot pay back the creditors for whatever it is. The sad part in this country is most personal bankruptcy was filed because of medical expenses. If you got cancer and you didn't have insurance, and the charge is like a couple $1 million, there's no other choice. But the test here is if I have so much debt that with the income I have now, this very moment, there is no way I can pay it back. Doesn't matter what kind of program I have, or just the interest alone for some people is a lot more than they make. I've seen people with, you know, a couple $100,000 in credit card debts and making barely minimum wage. So all that take into account. But the situation is as such that you don't think you can handle the financial situation that you're in anymore. then you have to explore the option of bankruptcy. You stop the creditor from harassing you. You stop your house from being foreclosed. You stop your life from being just disrupted in every way by these people going after you for the money that you don't have.
Right.
So alternatively, and I dealt with this before with a lot of people. They came in and I think, I don't think bankruptcy is the right solution for you. Here's something we can do, okay? Give me the list of your creditors, your credit cards and all that stuff. Let me see if I can negotiate with each of them to reduce the interest, to reduce the account and things like that to a level where you can afford under your income. Or some people would have somebody who would loan them a big chunk of money to pay off all those. Because when these people get into the financial situation they're in, it's the interest is killing them. If you have a credit card at 20%, you will never get out of it just paying minimum payment each month, and if you can get out of that situation alone, maybe you don't have to file bankruptcy and don't have to suffer all the consequences.
Right. Okay, excellent. And then, so steps then, if you say, okay, let's do it, let's file for bankruptcy, how long does it take? So what are the different steps that you need to do that?
Well, let's see, you have to have a good grasp of your financial situation. Unfortunately, clients do not. That's why they're in the financial situation that you're in, okay? When you file for bankruptcy, you say, court, this is all I have. This is all I owe. I throw it in front of the judge. The judge will give me back what they think is my exemption that I can keep. The rest, you give back to the creditors. And if there isn't a no asset case, then nobody gets anything. Everybody walks away. You don't have to pay them back. They can't go after you. Okay, so the financial records to compile is very important because that's how you list your creditors. That's how much money you owe and all that stuff. If you have a CPA like Community CPA, we can assist you with that. Just in assisting whether or not you need the bankruptcy in the first place. Okay, we can sit down and say, listen, this is your financial situation right now. The only way we can get you out of this is this, this, and this. Okay, and if we can't get you out of that, then here's the record. You can take that and go to a bankruptcy attorney and then have a consultation and see whether or not that's the option for you. We will not make that determination for you, but we'll give you all the tools to do that with. So it's very important to have that financial records. Oftentimes people will come in and say, I have a judgment against you. I mean, against me for, $100,000. I don't have any money to pay back. Okay. I have a car, I have a house and all that stuff. I don't want them to go after me for all of those things. We can go through the records, through the finance, through everything else and say, okay, creditor, guy who got $100,000 judgment, he's going to file for bankruptcy. You're going to get nothing. Okay. Or you can take payment for $10,000 and then discharge the case. We show them the finance and it's a game. Okay. Do they want to take that risk of losing that 10 grand that I just offered them when my client filed for bankruptcy? So it's not just the court procedure alone that we can help you with. It's the negotiation prior to that. Maybe you can get out of the situation you're in. I mean, there are times when we just say, okay, we'll file. But there's a lot of steps before that. Okay? So it's very important to have the records to compile. And then to expect a good lawyer give you a counseling without the ultimate end of just filing bankruptcy. because we're here to help client to straighten out their financial situation the best way we know how. And I think it's unethical for a lawyer to say, we're just going to file bankruptcy because I'm going to make some money and you get out of the situation. I have to look at the whole financial situation and say, this is the best step. Can I do this for them without file for bankruptcy?
Right.
So the fee that's being charged for doing that and everything is going to be less, and the process is going to be a lot more accurate and more favorable to the debtor if you have all the financial records, everything on up the line, and they don't have to investigate into all that.
Right. So these are things that you would do like before actually filing, correct? So you would
Right. The consultation with the lawyer is very important. I don't assume at any time that when I talk to somebody in financial problem that they're going to file for bankruptcy. That's not my goal. I mean, whether or not they're going to hire me to do the bankruptcy is another story. But that's not my goal. It shouldn't be. It's always to help the client the best way I know how. So that's the case, okay?
Okay, so somebody's considering it, they're compiling their financial records, at what point should they be seeking legal counsel?
I think they should be talking to a counselor or a lawyer or anything as soon as they can. When the situation is as such that they have a big judgment against them, somebody's trying to foreclose their house, somebody's taking action against them. It's never too early to do that. Okay, maybe other steps can be taken before you actually have to file for bankruptcy.
Right.
So it's never too early to seek counsel when that's that's in the card to straighten out the financial situation.
Okay, and then once you file the petition, then can you tell us a bit about the procedures that it would take? Okay,
so under the law that was passed about 15 years ago, the debtor have to go through an education about bankruptcy before the filing. So 180 days before filing, the debtor had to take a class, and it can be done online now, that show them what I'm talking about. The reason for bankruptcy and then the things like that, basically kind of like this, what we're doing today. And then that have to be filed with the petition. And it costs about $50, and we have a program that file bankruptcy that also incorporate that class inside of filing. So if you take it with that company, they will send us the certificate and we file it at the same time. So the fee for bankruptcy keep going up. The federal government are missing a lot of money. So when you file for bankruptcy, you had to pay the petition fee. I think it's now, don't quote me exactly, but it's $280-something. And the money most of it goes to the trustee. So when you file for bankruptcy, you have to list the schedule of assets, which is a list of what you have. And then the schedule of debts, which is all the money that you still owe. And then the exemption, what you want to keep. I mean, there are codes that allow you to keep things, but you have to do it right. You can't keep more than you're entitled, and you don't want to give up whatever you have either if you can keep it. Okay, so basically, you put the two in a pile and give it to the trustee. The trustee is not a judge. A trustee is somebody hired by the court to sort through the paperwork and make a determination of whether or not you can get a discharge from this, okay? So the trustee would contact the lawyer or the individual who does not have a lawyer and say, this is the information I need. I'm going through your petition and this is what I need. Okay, they can look at the payments that you make to creditors 180 days prior to filing. and say, okay, you can have that back. Because if you file today, the creditors wouldn't get that money. So if you file, you pay them 120 days ago, that means I want that money back. It become the part of the estate. When you file for bankruptcy, you create an estate. Okay, estate of the bankruptcy, kind of like when you die, it's an estate.
Right.
You file for bankruptcy estate, and this estate can be negative most of the time for Chapter 7, or it can still be a positive. And that estate have to extract anything that is still lingering out there, things that you pay and things that people collect from you illegally because well, not illegally, but they collect from you before they find out that you filed for bankruptcy after within 120 days. As soon as you file, they set up what's called a creditor hearing, a 341 hearing under the bankruptcy code. It's basically, the court will give notice out to all the creditors that you list. The creditor that you list will come in to a room normally at the federal building, but the last 3 months they had to do it online. I haven't done one that's online, so I don't know what it's like. So in that creditor hearing, the trustee will be there, and you have to answer under oath how much money you have, what's the kind of property you have, and then things like that. And your creditors, and some of them show up. Some of them don't, then they don't have anything to say. Some of them will show up to ask whether or not they can get their stuff back. Like I said earlier, if it's the collateral for a product, if you went to, Home Depot and buy a refrigerator and you're making payment on it under Home Depot financing, and 2 months later you file for bankruptcy, they're going to send somebody and say, can we come and get your refrigerator? And if you say, well, it's broke, or, I threw it out or something, then they have nothing else. They have no, but remember, everything is under oath. So the property, if you still have it, they can come and get it. Okay, same with your car, same with things like that. So say if you have a car and you're paying on it, the car is worth $5,000, you still owe $3,000. So there's a equity of $2,000 in the car. Are you entitled to keep that? Maybe, maybe not. Depends on how you file and whether or not you file single or with a spouse and things like that. So assuming that you can keep the car, you still have that $2,000 equity that has to go back to the estate somehow. So most of the time you make an agreement with the creditor. Let's say for example, would say, okay, you still owe $3,000. We will make an agreement within the bankruptcy itself, and then you can make payment under $3,000 alone, and then keep the car, the rest of the car. Another thing that happens when you file for bankruptcy, it creates a forum for lawsuits. People can sue you within the bankruptcy procedure and say, I'm suing debtor so-and-so because I think he's lying about how much money he still has. I'm suing because he say that the refrigerator doesn't work anymore, but he threw it out, but I don't believe that. Okay, so it's create a whole new forum, another court under your name that people can file for the lawsuit, and it create a whole court procedure for you to do that. So that need to be done. Those are actual trials for people to work out the dispute within the bankruptcy court. Okay. It got real boring, didn't it?
No, it's really interesting. So all of these creditors, they have to be resolved, right, in some way or the other?
No, they don't have to do anything. When you file for bankruptcy, you list the creditors, and the court will send them notice that we have a creditor meeting, okay? And they get a certain number of days after the creditor meeting to file an objection to the discharge of that particular loan or debts or whatever it is. Okay, so if you're a creditor and you don't think this guy is telling the truth, you can file the objection to being discharged that particular debt alone. Say I'm at the IRS, somebody filed bankruptcy. I'm a federal entity, so I can go and sue myself under the federal court and say that tax is not dischargeable because it's payroll check. You know, the danger is if the creditor don't think they can get anything out of it, they're not going to waste any time and money. But if they do, maybe they can stop the bankruptcy in their favor and then get that money back or that item back from them. So yeah, so they don't have to show up. But when they do, they get to question the creditors under oath. You know, like they were in court, and if the creditor, the debtor, do not tell the truth or trying to hide it, they can be charged with bankruptcy, fraud, and perjury under court. So it's a serious, you know, situation if they should do that. So if you ask the court to determine whether you can discharge these things, that this is my debt, this is my asset, and you lie about it, that's a federal crime. And the FBI prosecute federal crimes all the time. It's bankruptcy fraud, and people go to prison for that. So having said that, if there's no objection, you know, there's no discharge objection to any of the debts. If there are, then there'll be hearings set for that and things like that. Then the case will be discharged. The discharge means you get a little piece of paper to say, hey, your stuff is discharged. You don't have to pay these people back. And you hold on to this piece of paper. They ever come after you, you can turn them in for violating federal law. Before I say that, though, there's also a educational thing that you have to get a certificate for. The pre-discharge is another class that you got to get a certificate for, in which the debtor is taught how to manage their money and things like that to prevent things like that from happening in the future. I don't think it, you know, personally, I don't think it does anything, but it's another. And if you file that with the court, with the trustee prior to the deadline, then the case will be discharged. See, the ultimate goal of the bankruptcy is discharge. Now, the opposite of the discharge is the dismissal. That means that the court, the trustee doesn't think you're doing this right. And whether it's procedural or it's actual crime, the case can be dismissed. And dismissed, that means as soon as the case is dismissed, your automatic stay is over. They can go after you. It's just like it never happened. Right. And if your case is dismissed, they know your option is not that strong anymore, and they will go after you a lot stronger than without dismissal. And you will lose your filing fee, your attorney fees, and everything else, and get nothing out of it. People do it all the time when, even though they don't qualify and they don't think they meet the test and all that stuff because of the automatic stay. So there are cases that's dismissed voluntarily. They got the automatic stay, they got whatever it's worth out of it, and then they say, okay, I don't want to do the rest of this, and voluntarily dismiss their petition. Or the court, the trustee can dismiss that too. Even a debtor, a creditor can petition the court to dismiss your case involuntarily.
Okay, well, thank you so much for taking the time and going through this with us. If they have any questions, they can contact you. What is the best email to reach you?
You can reach me at iowalawyer@yahoo.com.
Okay, excellent.
Or my Community CPA, I also have one through there, don@communitycpa.com.
Right. And then if you have any other questions following this webinar, you can also reach out to Catherine at communitycpa.com. Again, we have these webinars every day of the week except Sundays.
Too ambitious. We got to cut it down to like 4 days a week. Can we do that?
I don't know. We'll have to ask Ying about that. But anyway, I wanted to say a last reminder that taxes are due, so please consider Community CPA for the July 15th deadline. And then, are there any final words for you, Don?
Sure. Thanks for letting me do this. And just remember that your financial health nowadays is very important. And we're, as professionals in the financial industry, are very worried about what happened after COVID-19 and all the assistance and everything is gone. You got to be prepared for that. Okay. Just like, you're taking precaution when you go outside not to catch the virus, you got to take some precaution regards to finance. See if you can survive this. We all have issues that we have to deal with during this pandemic, and I wish everybody good luck in everything that they do, including the financial aspect of it. And if we can help in any way, please let us know.
Thank you, Don. Very much appreciative. All right, everybody. See you next time. Again, Community CPA, 3 p.m. Thanks.
Thank you.